Dear participants to this lunch webinar, welcome. My name is Pascal Pichonnat, and as president of the European Law Institute, it is my privilege and my great pleasure to welcome you all to this lunch webinar on the guiding principles for automated decision-making in the EU. The European Law Institute, ELI, runs different type of projects, as you can see by going on our website, europeanlawinstitute.eu, and we have organized webinars around these different type of projects, public consultations, responses, and today it will be around what we call an innovative paper. The ELI decided 3 years ago to launch calls for innovative ideas that might not be in line with our project strategy overall, but which could open new ways of thinking, new avenues for future projects. And when the executive committee picked up the proposal made by Professor Teresa Rodriguez de las Heras Balel, we would not have thought to receive in the end such an impressive paper with 12 principles aimed at providing further guidance on establishing a true legal framework for automated decision-making in the EU. I'm sure that this webinar will help us understand the challenges, but also the inspiring proposals of this innovative paper that was put in front of the ELI Council and the ELI members for discussions, suggestions, and then approved. The ELI, of course, fully endorses these principles that have been provided and prepared by Professor Rodriguez de las Heras Balel, and I'm sure that these principles will provide further guidance to policymakers, practitioners, academics, and others working in this ever-evolving field. We have now 75 minutes to understand and then discuss these guiding principles. I will present the panel as we go along, but let me underline the exceptional quality of the panel here with 3 speakers from different type of stakeholders, if I may say so, and especially, of course, Professor Rodriguez de las Heras Balel. After a presentation by all 3 speakers, we will have a Q&A session for about 30 minutes, and you will be able to use the Q&A button, of course, to put your questions. Do not wait the end, of course, to put your questions in the Q&A section. During the first presentation, we will also get 2 polling questions to trigger your attention also to some burning issues. So remain active, of course, because it's lunchtime. You are allowed to eat your sandwich or whatever. We won't see you, though you will see us, so we are forbidden to eat at the same time. But these questions might be interesting also for Teresa and others to go on and see what we think about it. Let me already thank very warmly the panelists for giving us the honor of being with us today. I'm truly looking forward to their presentations and their reflections, which I'm sure will nourish us all in the field of ADM. Now, before listening to them, let me just remind you of these fact that you have the Q&A session and you shouldn't wait until the end to put your questions. Now, let's get started with Teresa Rodriguez de las Heras Balel. As you can hear from her very long last name, she's coming from Spain. She's the author of the innovative paper, and she's also an ELI executive committee member. She's chairing the membership committee as well. And above all, I suppose that's her main activity. She's associate professor at the University Carlos III in Madrid. In 2021-22, she is still the Sir Roy Good Scholar at UNIDRA. She is also, among other things, arbitrator at the Madrid Court of Arbitration and the Spanish Court of Arbitration, member of the European Commission Expert Group on Liability and New Technologies, and the delegate for Spain before UNIDRA and UNCITRAL Working Group 6 on securities or security interest. So you can see she has really a very broad understanding, especially also of these technical aspects, so to say. And so I think we are all thrilled to listen to you, Teresa, about these principles and what you wanted to achieve with the guiding principles. You have the floor.
Thank you very much, Pascal. It's a great honor for me to be today in this webinar with extraordinary colleagues contributing to the discussion on the principle for automated decision making. It was indeed a great honor, pleasure, and I'm very grateful, ELI, for creating this space that gave me the opportunity to produce, formulate these 12 guiding principles that were subsequently discussed by the ELI members with extraordinary and helpful insight from all of them. So the idea of my 10-15 minute presentation today would be to present the main component of this innovation paper. Essentially, what was the definition, the concept of automated decision making that is going to be instrumental to understand what is the scope of this principle. Subsequently, I would like to discuss which are the main actors involved in the deployment, the implementation, the use, and the operation of ADM, automated decision making, and how, taking into account this backdrop, I have suggested and proposed 12 guiding principles. In particular, I would like to focus on 2 of them that will be followed by a couple of poll questions for triggering the debate that is going to be subsequently discussed and opened after the panelist intervention. So let me please just share my screen in order to illustrate the main ideas that I would like to discuss with you. This guiding principle on automated decision making are defining principle for phenomenon that has been defined as automated decision making. The concept of automated decision making is composed of 3 main component parts: input, processes, and technique, and output. Let me elaborate a little bit more on this definition. The proposed definition of ADM is the following. An ADM is a computational process that includes artificial intelligence techniques and approaches, as well as purely algorithmic processes. And this is very important for the purpose of understanding, for example, which European Union legal act might be of relevance for the automated decision making. For example, the future Artificial Intelligence Act is relevant for this purpose because we are including artificial intelligence processes, approaches, and technique. So let me just start again. So we have an automated decision making that is a process, a computational process that includes artificial intelligence techniques and approaches that is fed by input that might be human-based input, machine-generating data, data collected from the environment, data provided by third parties. These input are feeding a system that, on the basis of predefined objective, generates a variety of output. So this is the definition used for the purpose of this innovation paper. What I would like just to discuss in a minute is what kind of output an ADM could generate. We are talking about a constellation of output. I'm talking about content moderation, rating, ranking, prediction, recommendation, online advertising, and so on and so forth. But what is important? Let me please make a distinction between those kind of output that, for example, a recommendation, for example, a prediction, that is going to be subsequently an input used by the person interacting with the ADM for an ulterior decision making. For example, a user that is interacting with the recommender system, that is indeed an ADM, received a recommendation what to buy, where to stay at, with whom to deal with, and this output become the input for a subsequent informed decision by the user. The second category of situation that we are also covering within this principle are those cases where the output of the ADM is the final decision that is going to impact or somehow affect on the legal status, the contractual status, the rights of the interest of the affected person. For example, an ADM that is a credit scoring system used by a financial entity in order to decide who is an eligible candidate for granting a loan. Or for instance, an e-recruiting program that is deciding who is a good candidate for being recruited by the company. So the output of this system is the final decision, the decision of rejecting or accepting, hiring or firing. This covers the scope of the guiding principle. And this is for me probably one of the most critical and important decisions that has to be adopted in elaborating this innovation paper. Who are the actors? Who are the person or the entities involved in this long ADM life cycle? There are two actors that are critical to understand how the guiding principle operates and can be applied and interpreted. First, the operator. The operator is the probably more legal person, more than natural person. So we're talking in most of the cases of operators that are companies that are involved and engaged in economic activity. But let me be general and neutral in this case. The operator is the one who employs, implement, and use the ADM for a particular purpose. For instance, the bank that use this particular credit scoring system, or the company that is using the e-recruiting app, etc., etc. As you will see, many of the duties that the principle advocate for are duties for the operator. The operator is indeed the key actor in the system, and in a way, the gatekeeper in ensuring that these expected principles are properly met, are properly complied with. On the other side of this interaction is the affected person. We could use a more general concept, for example, user, but the idea of affected person we thought that was very pertinent because we are trying precisely to identify those situations where the person is affected by the output of the ADM. Naturally, in the broader picture, we have other actors that are going also to play an important role. For example, the provider of the ADM, the importer, the data provider, the programmer, the developer, all of them will play, no doubt, also a significant role. If that is the case, you will find in the principle a specific reference. And let me please conclude in this definition of the actors involved, third parties. In many cases, the functioning and the purpose of the ADM is not only producing a direct impact on the affected person, but is also having some collateral impact on third parties. For example, a rating system or a ranking system or a recommender system may impact, for example, on the third party, who is the company that has been rated very lowly, or for example, that has been downrated, or has not been recommended at all, because probably the possession of this downrated company in the market is going to be negatively affected as well by the decision adopted by the ADM. With this very, very important key element, the guiding principle has been formulated as follows. What you are going to find in this document, the innovation paper, are 12 guiding principles with a title, with a definition or elaborated formulation of the principle, with some explanatory comment and some illustration. Example, use cases that try to provide a real case or hypothetical case applying or interpreting each of the principles. These principles are not in a vacuum space. They are naturally interacting and has been significantly inspired by other in progress or adopted, in particular, European Union legal act, GDPR, the platform to business regulation, but also the future rules that we are going to find in the DSA, in the DMA, in the Artificial Intelligence Act, or in the proposal of directive for the platform work. So in a way, it's at the core, it's a core document that is fed, but other very important principles and rules that are in the moment becoming more and more relevant in the European Union regulatory scene. Let me please provide you a very, very general overview of the first part of this principle. And let me just devote 2 minutes to focus and comment on principle 1 and principle 2, because both of them are very closely related each other, interrelated indeed. Why? Principle 2 is a very important principle, non-discrimination against IDM, automated decision making, that essentially say the follows. As a general rule, automated decision making shall not be denied legal effect, validity, or enforceability, and this is the key element, exclusively on the grounds that it is automated. So what that means that we don't need a specific, explicit, and case-by-case legal acknowledgement or legal recognition by the law in order to use or implement an automated decision making. As a general rule, there is no discrimination against automated decision making. But general principle 1 says, to the extent that, provided that they are compliant with the law. So the idea is this kind of automated decision making can be, in general, be implemented for any purpose in any activity as a general rule, but ensuring that they are complying with the law. Let me please probably discuss together the next principle, not principle 3, but principle 4. Why don't we together discuss the following? Let us start with the first poll question. That is about one probably of the most evident concern. Should we know as a user that we are interacting with an automated decision making? Should that be disclosed? So this is a question for all of you. The question is, considering the impact that affected person may have, what do you think that an operator should disclose that the decision making is automated? This is the question. When do you think that should be disclosed? And the question, the replies that you have, whenever is used as an input for decision or for adopting decision, whenever artificial automated decision making is used as input for decision or for adopting decision unless it is obvious or unnecessary from the circumstances and context of use or exempted by law, whenever is used for adopting decision, or whenever is used for adopting decision unless it is obvious and necessary. Sorry, it's changing the order. I'm afraid that I am reading again the same one. Okay, let's wait for the answer. But as you can see, there are 4 different replies options. And as soon as it's finished, we can discuss that. I see that the first option is prevailing. And it's a very general one that is said anytime that automated decision making is used. As soon as that's finished, we can discuss the consequences. So as we can see, most of you, 33%, consider that disclosure is something that should happen anytime that automated decision-making is used, indeed, as an input for decision. A very significant percentage consider that that should be the case, but with some exception, with some limitation. It is obvious, it is unnecessary, or is exempted by the law. And then less significant percentages consider that there are other, let's say, possible formulation of this principle. If we can already continue and try to see 2 of the illustration that we have proposed in the guiding principle, as you will see, the idea of the guiding principle is to be generous. I don't know, Pascal, if you would like maybe to intervene, please. No, excellent. So the idea of this principle is precisely to be very generous in disclosure, in the disclosure duty, but with some exception that maybe are not justified because it's obvious. For example, if you take a look of illustration B, it is evident that you are interacting with a rabbit, or illustration A, when is, however, less evident for the user of a bank app that all the process behind that app is going to be entirely automated. So as you can see, we provide certain illustration. We provide as well at the very end of the screen, you can see different ways of conducting and implementing this duty of, as you can see, of disclosure. And let me just conclude, because my time is about to finish, with another principle that I think is very important, because the rest of the panelists are going to discuss other principles. Principle 3 is very much related to principle 7. When a decision is adopted and taking into account that ADM is fed by the intervention and the action of many actors, data provider, programmer, provider, implementer, operator. So who is the one we are going to attribute the legal effect of the decision to? Guiding principle 2 is very clear on that. The decision is going to be attributed to the operator. For example, e-recruiting program, rejecting or hiring personnel. Who is the one rejecting or accepting or hiring? The operator of this system. And who is the operator? And this is something that we can discuss in the Q&A session afterwards. Our proposal in the principle is that the operator is the one on which two elements converge: control and benefit. The one who controls the system and benefit from using it. Let me just conclude with the second part of the principle in order to give the floor to Pascal and the other panelists. The other group of principles, as you can see, elaborate on these ideas, talking about certain limits and also talking about fundamental aspects, for example, the need of human action and human oversight, and even the need of human review of certain decisions. Let me please finish here, Pascal. I think that probably we can discuss further some of the principle. We have another poll question, but I don't know, Pascal, if you think that now is the time to do that, or we can do that afterwards.
Sorry, I think it might be a good idea to have the polling question right now, if you don't mind.
Excellent. I think it's a good idea as well. So if we can have, please, the next question. The next question is, in your view, to whom should the decision adopted by automated decision-making be attributed to? I anticipated our decision, but it's precisely a debatable issue. So we will be very happy to see what is your perception on this. Do you think that is the producer or the provider, the software, the data, the design? Do you think that should be the importer, the distributor? Is the operator indeed the right answer? Or there are other actors that we should attribute or allocate the legal effect of the decision to? As you will see, principle 7 is another angle on the question. It is not about the legal effect, it's about the risk. If, for example, this particular decision is causing damages, who is liable for that? We definitely may discuss that further because require elaboration. There are different situations that should be taken into account. We are about to finish with the minute that we have available, but I can already see, Pascal, that the majority seems to be in agreement with our proposal that the operator is the one that we allocate to the legal effect, but there is also a significant preference for the producer and the provider. 41% so far. Is not very significant at all. It's not relevant. The one who consider that importer or distributor should be this the legal effect allocating actor, and others 6% as well. So it seems to be the operator, the preference, followed by the producer or the provider.
Thank you very much, Teresa. I think we will stop here. We got the polls also, and we got this excellent introduction also on these very challenging issues about scope and some of the definition. I'm sure we will come back to that in the Q&A. I will now give the floor to Dirk Staudenmayer. I should not present him. He's a regular panelist in our webinars, and for that I'm thanking him very much, because I think it's a great great benefit for us to have his feedback and also his understanding of what is produced by the European Law Institute. As you know, he's head of the unit for contract law and of the DG Justice and Consumers at the European Commission. And he studied in France, in Germany. He's an honorary professor at the University of Münster. But of course, he has several lives. But the most important part of his life is for the European Commission, working as head of unit. And so he's got a specific position to understand what are the challenges in these evolving situations. And he will speak today about consequences of AI autonomy as a shift of paradigm in private law. And I'm sure that will fit in very nicely to what has just been presented by Teresa. Dirk, you have the floor.
Thank you very much, Pascal, for your kind introductory words. And thank you very much for ELI for inviting me. And thanks a lot to Teresa, and congratulations for this extremely interesting and thought-provoking paper. I have so many questions, and I would like to ask a few at the very end of my talk. So if you, I'll try to be short. Can I ask a question, Pascal? We are a bit behind schedule. How much time do I have? Until when?
You still have what is foreseen, so that's very kind of you, but you still have 10 minutes.
Okay, thank you very much. That's very kind. In this case, let us start. At the moment, I do not want to go into details about that, but the adaptation of the EU private law to the digitalization and to the needs of the digital economy is going in 3 waves. We had already the first wave in the 90s with the adaptation to e-commerce. We are at present in the second wave, where new products and services are regulated. Just thinking, for instance, about the DCD and the Digital Content Directive and the Sales Directive, which deals with goods with digital elements. And we are also dealing with new dependencies which appear in the digital economy, just to mention the proposals on the Data Act, the Digital Market Act, and the Digital Services Act, which deal with platforms, gatekeepers, and with the dependency situation of data holders and data recipients. But we're heading already into a 3rd wave of this adaptation. And what we're discussing today is indeed one of the features of this 3rd wave of adaptation. It's looming, it's there basically, even if it hasn't fully started yet. Now, and this is basically about AI. AI is enabling technology, and AI with specific features. And I would like to talk today about one, which is autonomy. Autonomy, so that is basically an underlying feature also under Teresa's paper, where an AI can take a decision which cannot be predicted, is not influenced and cannot be predicted by a human. And I submit that this is the key feature which makes the difference. You know, I'm feeling a little bit like the little Jewish boy who at the first Seder has to ask the important question, what is so special about this night? And the point is, what is so special about AI? And that is autonomy. Because autonomy makes the difference to what we had before. And here, this is already my first comment on the paper by Teresa, basically on the scope, because I think autonomy makes the difference to what we had before, and that's automation. Because in automation, we have the classical if-when situation. So a criterion is clicked off, a consequence happens. That's programmed, that can be traced back, that's still determined by a human. Autonomy is different, because in autonomy, true, the human still created the conditions, but the machine makes the decision on its own. It learns on its own, it gives itself its own rules, and then takes its own decision. And because of that, it cannot be predicted, and it is very difficult to trace it back. And that makes a decision in tort law, and it makes the decision in contract law. The difference in tort law and the difference in contract law. In tort law, the Commission is coming forward, and that's one of the pleasures I'm working on at the moment, with a Commission proposal on liability for AI in autumn this year, probably. And basically, here we will deal with a scenario. What happens if the victim has a burden of proof to prove fault and causality, but has really difficulties, first of all, identify who is the liable person at all. Teresa mentioned it with the discussion on the operator already. And then basically, if the victim was able to identify the liable person, how can the victim prove causality and fault with such an autonomous system acting? And there's for total, there's another feature of AI in addition, accumulating with that's opacity. So that's one issue or one area this becomes relevant. And the second one is contract law. And here, obviously, we will have a situation where a human is dealing, and Teresa made references to this already with examples, a human is dealing with an AI, or two AIs are dealing with each other, which I think is the even more interesting question. That's the famous smart fridge, yeah, but it's also much, much more relevant in B2B, and that will be supply chain management, because that will be much easier and much less resource intensive. So basically, in a nutshell, I think because of this feature of autonomy, that is the one which makes the difference, and that is the one we should focus about. You will understand why, because I will now speak about the consequences of this. But basically, I think that the existing law can deal with all the other features in their isolation and even in cumulation. But autonomy is a shift of paradigm. And there we probably need to do something. Now, what do we need to do? Or what are the consequences? Well, again, there are two areas which are, or two dimensions which are interesting. One is, and it's mentioned in the invitation of ELI, which was sent around, what happens with the existing law? Is the existing law as it stands adapted? And the second question is, do we need new law? And that has been recently discussed. Teresa was present in the UNCITRAL meeting. She was the delegate for Spain. And basically, we are looking at this also at the Commission level. Now, first question, is the existing EU adapted? I will not go into details, but just to mention one tool, one main tool, which applies in B2C and in B2B. And these are pre-contractual information requirements. As you know, they're mainly harmonized in the Consumer Rights Directive, fully harmonized in the Consumer Rights for distance contracts. And then there's also the E-commerce Directive, which applies also to B2B contracts. Now, these two directives contain a list, in the case of the CRD, and a relatively short list in the case of the ECD, in terms of pre-contractual information requirements and contractual information requirements. And the question is this adaptive? Now, if one reads the list, it becomes pretty obvious at which age they're done. There's still a remainder from my first wave, adaptation to the e-commerce, because they presume that contracts are concluded through sending an email, through clicking on a website, and they're not at all adapted to not even voice assistants, yeah, like Alexa, but certainly not my smart fridge, who may be contracting himself with say a vendor and the AI of that vendor. So basically, the question here is whether these, well, it's not so much whether, it's more how these requirements should be adapted, and if so, with which principles in mind. And that's why, one of the many reasons, why it is so extremely useful to have this paper by Teresa. And because here, just because I'm speaking about pre-contractual information, we will have the question, for instance, does pre-contractual information still make sense if two AIs are contracting with each other, or if an AI is contracting with a professional seller? Because the whole idea about pre-contractual information obligation is an asymmetry in information, a structural imbalance between the consumer and the seller. The idea is to lift up the consumer to the same level as the seller. And then they have more or less equality of arms, not really, but more or less, basically. Yeah? Now, my smart fridge would know much more about the market than the seller, because it has access to the internet and knows everything Here, suddenly, market transparency is no longer a wish word, it's reality. So basically, what does it help to inform my AI about, say, the characteristics of the goods, the prices, etc., etc.? It doesn't need that. It knows everything. Yeah. So basically, if one probably definitely needs to keep contractual information ready, because that helps the consumer, the human behind, to after exercise his rights if something goes wrong. But pre-contractual information, one need to think about what one needs if there is AI contracting. Finish this point. Basically, new law, well, that depends on what the result is of whether we need to, and to what extent we need to adapt the existing law. So for me, this is still an open question. I do not know that the answer, but the question is important. And again, Theresa's paper is very, very helpful. So in the few minutes I have 2 minutes left, if I may, would like to ask a couple of, actually a few questions very briefly, on my more detailed comments on Theresa's paper. The first one is a remark. This is extremely useful to have this kind of conceptualizing, very useful, because especially for these reflections I mentioned, do we need to adapt existing law and do we need new law? Such kind of conceptualizing is the first step. So very, very useful. And then I have 3 questions which I wanted briefly to ask. The first one is a more fundamental question, not related to a specific principle. And that's a bit the elephant in the room, if I say so. It's the definition of the operator. So why are we excluding non-professional activities? Because that means that whatever a private person does, or a private person does in tort or in contract, is excluded. And that's very relevant. If one discusses who is the operator, or to whom activities should be attributed, it may make a difference if you're speaking of a professional operator or a private operator. It may not, but it may. And it's therefore rather relevant. So that's my first question. Why excluding non-professional activities? It becomes also very interesting there. And then I have 2 more precise questions. One is about disclosure. On your principle 4 here on page 17, you are advocating for a case-by-case assessment for determining the need for disclosure. I submit that that's not very helpful for the angle I come from, because as somebody involved in lawmaking, it would be much more interesting for me to have this made more schematic, because that provides legal certainty, and to allow to include this into this requirement into any to be adapted or new legislation. So that's my first more detailed comment. And my second more detailed comment is on principle 5, on traceable decisions. Here, page 18. Does what you are requiring mean that the forms of AI which are really, really interesting, the highly developed forms, are not allowed on the market because they're not traceable? That would be a pity. So thank you very much. Highly interesting paper. I'm loving this paper. Looking forward to the discussion. Thanks a lot for your attention.
Thank you very much, Dirk, for this very inspiring also presentation, and putting the right angle on the autonomy as a central feature, and then getting to these questions. We have already questions in the Q&A part, but I'm sure Theresa will love to come back also to these questions. But first, let's get to our final panelist for this afternoon. I say afternoon, but for him, he's sitting in the US. It's just a very, very early morning. So thank you very much, Mark Rosenberg, for being with us so early in the morning. You are the founder of the Center on AI and Digital Policy, and also an adjunct professor at Georgetown University Law Center. And your expertise is well known in data protection, internet policy, and you advised as an expert many important international associations or organizations like OECD, UNESCO, and other UN bodies. So it's really a pleasure and an honor to have you here on this lunch webinar. Of course, last week you were also on a webinar with us, but it was in the evening for us, so it was even more agreeable, I suppose, for you. But we are thrilled to listen to your comments, and I give you the floor.
Thank you very much, Pascal. It's a great honor to join you today. Wonderful to see Teresa and Dirk. And I do want to say how very impressed I am by the contributions that the European Law Institute continues to make to this rapidly emerging field of digital policy and artificial intelligence. I think it's very vital for ELI to be an active participant as laws are being formed and new norms and standards are created. And in this respect, Teresa's contribution with the guiding principles for automated decision-making is absolutely brilliant. I undertook a similar exercise myself a few years ago, which I'll come back to toward the end of the presentation, but I wanted just to begin by highlighting some of the features of the guiding principles that stand out. And of course, you know, many of us undertake the aim of setting out policy frameworks in fields of law, but to do this well, I mean, you need goals that are complementary, not duplicative, not contradictory. And I went back and looked at how well the pieces fit together. And I think they actually fit together exceptionally well. There's a sense that this is a foundational set of principles. There are cross references, questions that are left open in one section are addressed in another. So that seems to me one of the key metrics for evaluating this enterprise. And the other point I want to draw attention to is that I think also the paper does an exceptional job of drawing attention to the roles of the various participants in the automated decision-making ecosystem. We need to differentiate, for example, between the operator. I like this phrase, the affected person. In the realm of privacy law and GDPR, we talk about the data subject. But I think the phrase affected person actually speaks more precisely to the individual who's going to be subject to an automated decision-making for credit or for employment or for criminal sentencing, and it makes real the contours of the outcome. To this point also, I just wanted to add, I think Teresa correctly observes that the responsibilities in this domain are properly placed on the operators of ADM systems. And as she says, these are the actors who are going to derive the benefit. And I think we would understand as a traditional principle of law, they should also bear the costs. But I'd also like to point out, from an economic perspective, this is an efficient outcome as well. Typically, we allocate rights and responsibilities asymmetrically, and we do this in part because those who deploy the systems have information about the operation of the system that is simply not available to the person who is subject to the system. And this is a form of information asymmetry that we recognize and place a responsibility on those who design, precisely when to use a system, which factors to consider, what weight to give an outcome. So information asymmetry is one reason that helps explain why the principles focus on the operator of the ADM. A related principle is the concept of least cost avoider, which is to say that if you are the manufacturer of the product, you are simply in the better position to minimize risk. And we understand the benefit in our economic system if we can properly allocate that liability, not because we're necessarily pro-consumer, anti-business, but because we understand that the business is simply better equipped, for example, to manage the responsibilities of the width of the brake lining on the rear rotor of your automobile. We can't go out every morning with calipers and check the lining to make sure it's 3 millimeters and not 2. We say that's really for someone with more expertise than we, the typical car driver, would have. And so that is also carried forward in these guiding principles with regard to the responsibilities of the operator of the system as it should be. And my final note on the principles, I think there's also very good use of illustrations, so that when we're talking about these principles, we can also see in practice how they would be applied. I appreciated the pairing where we might see the, high priority application where there's a outcome with legal consequence versus a low priority application, I think having to do, for example, with allocation of classrooms. Now, of course, for some students, that may be their high priority concern, but I think as a general matter, the responsibilities that we might impose on the operators of an ADM system would be diminished in that particular case. So I thought very good use of illustrations. Let me say a few words about the key principles that I was asked to address. When I, as I said, undertook this exercise a number of years ago, I placed transparency as the #1 goal as we thought about the regulation of AI systems. And I was particularly concerned because I thought without transparency, there would be little accountability. But I like the way the ELI paper explicates transparency through 2 additional principles. So, for example, in Principle 5, we have a mandate for traceable decisions, which says that ADM shall be designed and operated in a manner that enables the traceability of any decision, and a bit of explanatory text that tells us this is not equivalent to the principle of transparency. This is a decision-specific exercise upon request or under certain circumstances. And we have, I think in the example of tax determination, some concern that might be raised by the person who's subject to an algorithm as to the fairness of the tax determination, and simply wants the ability to go back to the agency and say to the agency, please validate this result. Please prove the outcome. Please help me understand why I'm now facing this liability. And I think this is a very sensible and also important principle. Now, I will note, and I believe we discussed this in an earlier ELI panel, that there are going to be competing interests. Businesses will say, well, we don't necessarily want to reveal to you our trade secrets because that's the value of our company. Or government agencies might say, well, we don't want to necessarily reveal to you how we proceed in a national security investigation because then there's a risk of circumvention. So we will need to anticipate some of these competing claims with regard to traceability. There are various mechanisms I think, to address the challenges. But I think the principle is absolutely correct. And in a similar light, guiding principle 6, which is about reasoned decisions. This is, of course, close to my heart, because when I talk about artificial intelligence, one of the points that I make is that AI has changed dramatically from the 1980s when I was starting with expert systems and we were looking at decision trees and we could make adjustments and coefficients if we didn't like outcomes, to the present day in machine learning, which is largely black boxes. And frankly, the developers of these systems themselves don't fully understand how the outcomes are produced. They can't be replicated in the traditional sense. They can't be proven in the traditional sense. And I think this is actually raising profound questions in the philosophy of science, what we mean by the scientific method when we produce outcomes that actually can't be proven. So I like this principle. I think it speaks specifically to the challenge of machine learning and the production of results that, while against data may be impressive, nonetheless as a matter of logic come up short. And just one short example from my own history, I remember a number of years ago, it's probably 15 years ago, when Google acquired the company YouTube. It was not created by Google. It was an independent company. And in the early days, YouTube used 2 ranking systems. One was for hits, literally the number of times someone went to a particular video page. And the other was for rankings, which is to say the number of stars that were assigned by users. And both of these were objective metrics. They could literally be proven by examining the scores that had been assigned by the users. Well, after Google acquired YouTube, they introduced a new metric, which became the dominant metric, which was relevance. Now, of course, this is subjective. It's a trade secret. It's also the basis of much of the search ranking that occurs. It's not even clear sometimes with Google if they can prove why under the relevance schema, one page appears above another. But I think this also speaks to the challenges we have as we move from more transparent systems that are provable to more opaque systems, the need to make sure that there's accountability and not excuses, which I guess we could also imagine with more machine learning outcomes. I liked also the guiding principle 9, human oversight in action, and clearly a human in the loop is important. I will say, having spoken on panels with judges and others, frankly, their concern is that even if they are in the loop, they may not be in a particularly good position to second guess a very sophisticated algorithm with a lot of expert assessments and results behind it to help support the decision it has reached. And so you have judicial decision makers sometimes just throwing up their hands saying, well, I can, you know, add my voice, but I literally do not have the scope of investigation that this device has been programmed to obtain. So we're going to have to how to think about making meaningful the human oversight principle. I think one key term, which is also raised in Principle 8, is the notion of contestability. And that is that people will need that mechanism to go back to a person who ultimately will bear the responsibility for the outcome. And I think that's addressed, as I said, in Principle 8. Finally, guiding Principle 11 is very interesting. I will say, frankly, that as much as I'm, you know, sympathetic to the goal, and I even saw my favorite phrase in guiding Principle 11, which is democratic values, I worried a little bit that this is a broad principle. And of course, when you have broad principles, you almost immediately start to ask questions about the scope of legal certainty. How do we implement the principle in a way that, you know, operators will in fact have fair notice of what their obligations are? And it's not entirely clear to me how we achieve that goal. On the other hand, it was interesting in this principle that we do begin to recognize the need for prohibitions. And there's a reference back to guiding Principle 1, I believe, and the importance of legal compliance. And here we have in Principle 11, a statement that says, well, in some circumstances, we may simply need to say that this AI system needs to be prohibited. And I'm going to end here simply by referring back to the principles that I had helped develop a number of years ago. I was at the time working with the OECD and very happy about the work that they were doing. And at the same time, feeling that the principles that they had developed wouldn't cover all the problems we were anticipating. So when we developed the universal guidelines for AI, we set out also a dozen, a convenient number, a set of rights and responsibilities regarding the use of AI systems. As I said, we put the right to transparency at the very top. Some of this language is actually taken from the GDPR, as well as the Council of Europe Modernized Privacy Convention, regarding a right to access factors and logic and techniques that produce the outcome. But as you know, we go through these principles, and you're welcome to find them online. I will draw attention that toward the end, one of our key goals was to be very explicit about the AI systems that we thought should be prohibited. So we were against systems of secret profiling. You'll see that in 10. We were against what we called unitary scoring, although I think today is most often called social scoring. And I'm pleased to say, by the way, that the UNESCO recommendation on AI ethics actually took on board this prohibition on the use of AI systems for social scoring. So that was a significant achievement. And then our final principle was the termination obligation, which is that if human control of the system is no longer possible, we said the institution, or in Teresa's formulation, the operator has an affirmative obligation to terminate the system. So this is not just about Hollywood movies. It's about our day-to-day experience of networks and Internet of Things and other ways in which we can anticipate automated decision will take over so much of our social activity. So again, wonderful, useful, and timely set of principles that I hope will become the basis for future work and incorporated in particular into the EU AI Act, which is now under consideration. So thank you very much.
Thank you very much, Mark, for these very astute remarks and discussion as well. And we see this change of paradigm even by comparing these two set of guiding principles, because there's in a couple of years now, 4 years between the two, a lot of the differences that are linked also to the evolution of technology. And indeed, machine learning is evolving itself, because now we have more and more AI in a position to reopen the box to at least see how things have evolved in terms of processes, which is already a first step to have a bit greater transparency, or at least greater traceability, if I would say so. We have a lot of questions, both put by the panelists themselves and others that have been raised by the public. And I see that there were, and maybe we will begin with that, and I will ask Teresa maybe to react on that, a number of questions around the operator. As you said, it's the key feature. And here you mentioned also that an operator will be identified through two aspects, control and benefit. And well, the question of accountability and liability might pop up later. But the question is the following. We have two questions. One is, how do we deal with the fact that control and benefit might be split between different people or different type of people? And how to deal with a case where the entity whom benefits the item is not the same? Oh, no, that's the same question on a different way. But also, yeah, if you have several softwares interacting, so interaction between several softwares, but at the same time, benefit and cost between different people, that might have an impact on the definition of operator.
Thank you, Pascal. All these questions are indeed very relevant and very insightful, because it is not easy in this ecosystem, as Mark was referring to very rightfully. This ecosystem of actors is not always easy to apply a concept that is in a way mono-based, no mono actor. Only one actor has to be the one that we need as a gatekeeper. So reality is definitely more complex. But the idea of the principle and this idea of allocating on a single actor, the operator, the legal effect and the risk, and we can discuss further about the liability because it's indeed more nuanced and more complex. The idea is that the operator, even if has not direct control on the system, should take all the measures and should do all the best effort to be sure that even if this control is in a third party, the system is complying with the law, is complying with the traceability principle, is complying with the rest of the requirements. So in a way, it's a kind of incentive generating tool. So the idea is to allocate the incentives and say, if you are going to be the operator, if you are going to benefit as a bank of using credit scoring that is clearly going to reduce your cost, you have the obligation to control. And if you don't have the possibility of controlling, you need to take measure to guarantee that the one who has the control comply with this requirement. So in a way, it's the same idea that when we talk about supply chains, the idea that if you are at the very end of this chain dealing with the end user, you are the one who has to guarantee that all the previous actors involved in the supply chain, they are complying with certain requirements, with certain values. So it's essentially a way, or at least an attempt, to put or to allocate the incentive on the operator, to be extremely careful in guaranteeing as the visible face vis-a-vis the end user, vis-a-vis the affected person, to guarantee that the control and the benefit are indeed a mechanism to ensure compliance with these requirements. So it is true, Pascal, that this question raised a realistic approach that is not always the case. There are cases where these two elements are scattered in different operators. That is completely true. So the operator should know, okay, I am responsible for that. I am accountable for that. I should take the measure to guarantee that cannot be an excuse. I am not controlling. So if you are not controlling, probably you should not use. That would be the idea, Pascal.
Yeah, thank you very much. I understand behind the question also the question whether there need to be only one operator, or whether the qualification of operator might also be on that party who has control but no benefit. In your example, you focus on the one having benefit without control, and that's his or her problem now to make sure that the one who has control will ensure, you know, to comply with all the duties. But what about the controller that has no benefit? Could he also be forced directly by third parties as an operator, or would you not qualify such an entity, let's say, an operator?
That is a great question, Pascal, and probably is very much related to the question raised by Dirk about the use of ADM in the context of professional and economic activities, or also for non-professional activities. The idea of the principle, even if we have discussed in depth to which extent the scope should be broad or more narrower in this case, finally, we adopted the idea of this principle are focusing on economic activities precisely because we wanted to stress that point, the fact that ADM are incorporated in an economic activity with a clear benefit, with a clear aim for reducing cost, enhancing the effectiveness, enlarging the audience. And this benefit at the very end become the kind of element that make this controller at the very end as well the operator. So if we have the scope of professional activities, I think that in most of the cases, we will manage to identify always a kind of benefit. Any kind of benefit. Being controller without any kind of benefit maybe is a very, very unlikely situation. I hope that that probably reduced the risk of not considering this kind of situation properly.
I see. Thank you very much. I will continue to ask questions. One is linked to this human in the loop. Is that always possible? And of course, this is also linked to this idea of explainable decision, and therefore it should be explainable, so to have a human. And Mark mentioned the difficulty sometimes for practitioners, for judges to understand, of course, what is produced by the machine learning or by AI in general. Maybe I would give you the floor first, Teresa, but I see that Mark unmuted himself, so maybe he wants to react as well. But maybe Teresa first, because you put that also as a requirement, right, to have humans in the loop. So. Principle
Exactly.
9.
Pascal, thank you very much. Mark will probably elaborate on this issue with a lot of insightful comment. The idea of having the human in the loop or on the loop is precisely to avoid this idea that, as Dirk mentioned before, autonomy means a total detach, a total delink of the system, adopting decision, affecting the affected person, impacting on the environment with absolutely no connection and probably no potential control, review, or action to alleviate or mitigate or prevent these risks from human. So it's in a way a natural consequence of the idea of operator. In a way, we always are gravitating around these ideas. You have control, and this control should be deployed when it's necessary, when it's needed. And naturally, human review, and in this particular case, human oversight, doesn't mean that we are losing all the benefit of automation per se, because automation means precisely that the system is working without human intervention. That is the purpose. And that is probably the reason why they are beneficial, of course. But human oversight means that this automation feature should not be excused not to control or not to assume the consequences, and therefore to have always the power to intervene when that intervention is necessary. As a principle, is naturally overarching, is naturally broad, but that is at least the aspiration, no? the goal that is behind this principle.
Thank you very much, Mark.
Well, I would only add that these same words will have different meanings depending on the context. And so from one perspective, we can think about human in the loop in terms of agency, and we can say, you know, ultimately it's the operator that's responsible, and we don't want to give legal personality to AIs, for example. And that's a very important understanding of this phrase, human in the loop. But as I suggested earlier, when we talk about adverse outcomes for affected persons, and we have a notion of contestability, we need that person to be able to go back to the operator with some meaningful procedure to contest the outcome that doesn't leave the operator simply saying, well, this is the decision that the system produced. In other words, simply restating the outcome. And so now we have human in the loop more through the lens of procedure and fairness to ensure that the outcome is in fact the outcome that was intended. And I anticipate, I'm now actually working on a textbook in the field, and I anticipate that this concept is actually going to carry over to several different strains of law in the AI realm. They will have different meanings, as I said, depending on context.
Thank you very much. I have a question that is addressed to Teresa, but I will address it to Dirk because I think he might be better placed to answer the question. I don't know, we'll see. The question was put like that. How would these guiding principles apply on the scope of the AI Act? I feel as if they overfly all their content. And to answer that, of course, one needs to take the AI Act as a focus. And maybe Dirk, you may answer that question first. Or not.
Well, I'm obviously the man from Brussels, but I'm not responsible for the AI Act, actually. But yeah, well, I'll give it a go.
Right. I know.
But basically, I think many of these principles are already at the basis of the AI Act. Not all, but some are. I mean, the AI Act has to strike a delicate balance between, on one hand, protecting safety ex ante, protecting fundamental human rights ex ante, and on the other hand, making it still possible and attractive, economically interesting to produce and market AI systems. Because the overall purpose of the AI Act is to promote the rollout of technology. And in order to do that, it wants to create trust. And for that, again, it has the safety rules and the implementation of these safety rules and the protection of human rights in mind. Many principles are in there. The discussion of human in the loop, human on the loop, was, for instance, a discussion which was very lively held before the AI Act was adopted. I think with many of these principles, if you try to put it in legislation, you have to take a pragmatic view. There is no, you cannot incorporate them one-to-one, basically. You have to try to put them in pragmatic rules, which, yes, are obviously based on principle, but as I said, are taking into account the interests of the digital economy in producing and using AI, but also legal certainty, giving the judges, and in the case of the AI Act, the supervisory authorities, the right tools at hand. And that means, above all, legal certainty and guidance, how to apply those rules. So it will, in all cases, be a fine balance between reconciling different objectives which are required. So I see these principles, and that's why I said I found it so extremely important that they're conceptualizing. I see these principles as a starting point, as a bit of a basis for anything which will flow into the law, and the ELI is a perfect example for that.
Thank you very much.
Answered the question.
Yeah, no, I know, but I thought it might be interesting to have the voice from Brussels. But maybe then I take a second question, and then I may come back to Teresa. Second question, which is linked to the liability and the question whether the operator or the producer should be held liable also in some situations. And there, Dirk, of course, you are more on your battlefield, and so I was wondering whether this distinction between operator and producer may bring some difficulties in these guiding principles, because of course the operator might not necessarily be the producer, and we have this product liability directive, of course, dealing with that. And how would you react on that question, this nuanced version of operator because of the producer liability issue? As you see, Dirk, I try to bridge.
You wanted me to respond?
Yeah, first, yeah, and
okay,
then give
sure.
Teresa a way to react.
Well, absolutely. I mean, first of all, there is not. It's not like there can be only one. Yeah. Basically, there can be several liable persons, and there are in reality several liable persons. Yeah, obviously, you have fault liability, you have producer liability, and you have strict liability. These are the three columns, basically, of all liability systems as we have in the EU. And so, basically, that may be different persons. There may be they may be wearing two hats. Yeah. So if you have an automobile producer, for instance, who their future business models of autonomous vehicles, in all likelihood, will be fleet operators who produce and operate the fleet at the same time. Really much less private-only owned cars, because they'll be too expensive. So basically, then at this case, I don't want to mention any name, but that operator will be at the same time the producer and that company will be at the same time the producer and the operator, and liable on both claims, basically. So, but there may be other situations where the producer and the operator is the same, so they can be the same. However, I think as an operator, it's the level of control which matters here. Like Teresa, I'm very much on the basis of the expert group report, when the expert group report at the time made the distinction between the front-end operator and the back-end operator. Yeah? What counts is really who influences and that means who controls the AI system. In general, I'm very much for the operator, and I was not allowed to vote, but I would have voted also for the operator, very much for the reasoning Teresa has explained. And I've also agreed with her. I think there's no operator, no controller, which has no benefit. There's always a benefit in there, actually. Because I'm speaking, I wanted to make it's a link to liability. I wanted to link to something what Mark said before. He spoke about the competing interests on traceability. That is very important, and you will see this when the proposal comes out, because basically disclosure duties are becoming very important. Yeah, if you are put yourself in the role of a victim, and you're thinking about, you haven't decided, you're thinking about doing a lawsuit, but you would need to assess whether this has chances. You would need some information. And here, pre-trial, and then later on, in-trial disclosure becomes a very interesting tool for pre-trial to avoid legislation, not going into the American, no offense, Mark, the American war with fishing expeditions and so on, but still allowing the victim to assess, has my lawsuit chances, and then in the trial, definitely, in order to get the necessary information which will help you to substantiate your claim. And that may go against the defendant, but it may also go against other parties. So for instance, if you're suing the operator, you may think about a possibility of a disclosure a claim against the producer. If the producer has logged, and is obliged according to the Act to log certain information, which only the producer has and not the operator, may be interesting to have the disclosure claim also against the producer. So very interesting question here, which is linked to liability and to these competing interests. Thank you very much.
Thank you very much. In light of the time, maybe I will first give a last word to Mark and then go back to Teresa so she can say some final words, and then I will close. So Mark, if you want to react or say something specific, you're welcome.
Just very briefly, as I said at the outset, I think the timing of the contribution is just about perfect. I mean, Dirk is correct. The EU AI Act is underway. Some of these issues are addressed, but the act itself is very complex. And when we talk about the regulation of ADM, I think we need a foundational, coherent, principled approach that allows people to enter the field with some signposts as to what the critical considerations will be. So I see in this report, the guiding principles, precisely that overview that allows a better understanding of the legislation, such as the AI Act.
Thank you very much. Teresa.
Thank you, Pascal. Yes, thank you very much, Mark, for this precisely this comment, because I would like to highlight this idea. The main aim of this principle is precisely to provide a consistent and coherent set of principles, as broad as possible, as comprehensive as possible, that guarantee that provision, rules, or principle related somehow to algorithmic decision-making, autonomous decision-making, are not scattered, maybe insufficient, or maybe even worse, incoherent each other. So I think that this is a very good timing for European Union in particular to ensure that all these extraordinary important legal action that are on the way are not only the right solution, but also consistent and coherent each other, because it's fundamental to have a very well established, consistent framework. That was precisely the idea of this humble principle, no? to lay the foundation and to guarantee that all the specific rules that might be in some cases elaborated and formulated, they are very clearly built on this common principle. That is precisely the idea of this principle. And I very much appreciate not only the question, but definitely the comment and the intervention of the panelists. Thank you very much.
Thank you very much, Teresa, and thank you to all three of you for your wonderful inputs, and also for everyone who attended this webinar or might listen to it later on, because it will be posted like our previous webinars on our website. So you will be able to go back and reflect more on what has been said, of course, but also on some other points that have been tackled, be it by Dirk Staudemeyer, by Mark Rothenberger, and of course by Teresa Rodriguez de las Heras Balel, who produced this innovative paper that, as we've heard, was very well received, considered as an important piece. And I can only underline this as president of the European Law Institute, how important it was to get this proposal and get this paper finalized in a way that was really splendid. So thank you to all three of you. Thank you to the speakers, to the panelists, no, to the attendees, sorry. And that's probably because I'm in need of eating something right now. So my brain needs some sugar, or at least something. So I wish you all a wonderful afternoon. Thank you for being with us, and see you all very soon. Bye-bye. Thank you very much.